This is Michael Popok, and by the looks of things, it's time for Legal AF After Dark. Here's a fundamental thing that the Trump lawyers don't understand. When you have an appeal, and you're taking an appeal from another court, and the Supreme Court tells you exactly the one-sentence question that they only want addressed in your appellate papers, your appellate papers should actually address the point that's been raised and is found interesting by the Supreme Court. And you shouldn't spend an entire 50-page brief running away from the question or literally ignoring the lower court's decision against you by the District Court of Appeals, which ruled against you on your immunity issue. Immunity. You're going to hear a lot about it because we got 3 separate briefs that are going to be coming in fast and furious time on a tight briefing schedule set by the United States Supreme Court as they get ready for their April 25th oral argument. And the first brief is in. It's by Donald Trump. Well, I mean, they're calling it a brief. We'll tell you more about it right here on Legal AF. Take a listen.
Popok, as you talk about, this final issue where Donald Trump is trying to basically say that he should get the powers of a dictator. He filed the opening brief claiming that he should get absolute presidential immunity. And one of the facts that he cites to the Supreme Court is he says that as part of his official presidential responsibilities, he was given the information that there was pervasive fraud when, again, that's just totally false. Like we know, we watched the January 6th committee. We've heard what Bill Barr, Trump's own former attorney general, said. They all of Trump's lawyers, Trump's attorney general, Trump's DOJ, all of the courts, including Trump appointees, all said that there's no fraud. But, the MAGA Republicans want to give the January 6th committee the names, unselect committee, they deserve to go in jail. And then they pump this North Korea, Russian style propaganda. They pump it. And then they, push out these bad faith arguments and hope that the federal judiciary is so scared of Donald Trump that they won't do the right thing. So I'll let you take it away, Popok.
Yeah, I mean, you wouldn't know it by reading the brief that Donald Trump filed through John Sarro, the lawyer who lost badly at the D.C. Court of Appeals. He's the lawyer that got all tied up in knots when Judge Pan asked him, so you're saying that the President of the United States can order SEAL Team 6 to take out a political rival because he was president? There's absolute immunity, especially if the Congress in its impeachment and conviction process wasn't able in the time remaining to convict him. Is that your argument? And John Sarro did a lot of double talk and said yes. And she said, I'll put you down for yes. And you wouldn't know what the arguments were because John Sarro's brief almost completely ignored the heart. There's only one issue that the Supreme Court is interested in. They're not interested in hearing about you have to have conviction in the Senate before a president can be indicted in a criminal court outside of the Senate, because that's not true, and they don't want to. That's not the appeal they want to hear. They said particularly what they want to hear. They don't want to hear about due process. They don't want to hear about structural immunity issues. They have one issue: can a former president use immunity concerning a criminal indictment based on official acts? So you got official acts analysis, former president analysis, and immunity analysis. Instead, they stuffed this brief filled with just a ridiculous collection of losing arguments, cut and pasted from the first brief that lost the D.C. Court of Appeals, barely acknowledging the only issue on appeal that is there, acting like we're going to reframe the appeal. This is the appeal that we want, which is always a bad place to be because it's just so easy, especially when now John Sarro is going to be arguing this apparently on the 25th of April. Oh, God help us. Although we will be able to listen to it and report on it on the Meidas Touch network. And it will be fun. I will get a big barrel of popcorn for it because he's going to get slayed by a lot of the judges and not just the what we call the left-wing judges. They did a lot of pandering. Let's pander to Kavanaugh. Kavanaugh, before he was a judge, wrote a law review article about why you shouldn't indict a president. He was really talking about a sitting president. But they love that. So he took quotes out of context and said, Kavanaugh, well, you're going to love this. Look at this argument. And then just stitched together ridiculous failed arguments that have no historical precedent. My favorite line in the whole brief, one of my favorite lines is, one of the things you should look at is that in 250 plus years of our republic, there's never been a president, former president has been indicted. That is long-standing precedent that it shouldn't happen. We've never had a criminal ex or current president before. That doesn't mean that when we found one, that the criminal justice system was unable, based on their interpretation of the Constitution, to bring this person to justice. Even this majority of the Supreme Court, I don't believe, wants the precedent to be that a rogue criminal president outside of his official conduct can get away with it, can get away with murder. Don't think that's going to be the case law that's going to develop from this. And they're going to get into the weeds about his official conduct. Now, I think things that he is permitted to do, that he is given as the executive branch and as the president, that are within his bailiwick, like conduct foreign policy, commander-in-chief, things like that. They're going to give him a pretty wide berth, without finding anything in there criminal. But nothing about candidate Trump trying to cling to power and interfering in mechanisms for which the presidency has no role. The counting of votes, the use of electoral certificates that are fake and phony, calling up various state officials, elected and election officials, to try to convince them to overturn the will of the people. What does that have to do with Article 2 powers of a president? How is that the president's responsibility? And for him to say, well, the president's responsibility is to ensure a fair election. It isn't. It isn't. Perhaps the Department of Justice under him, perhaps the federal court system, Article 3 judges. The president of the United States is not the super cop related to election fraud, even if there was any. And that's the problem with their brief. So you and I, having digested this mess of 60 pages and trying to find any cogent argument whatsoever and finding none, we're now going to wait patiently on the briefing schedule set by the Supreme Court for the brief of the special counsel, Jack Smith, and another brief that both me and, more importantly, somebody like Judge Ludig has asked for, that the 10th Justice, the Solicitor General of the United States, who's often referred to as the 10th Justice, right, weigh in and file a brief. I know that Joe Biden wants to be above it all and act like, well, this is my opponent, so I want to stay silent. This is too important of an issue. And the Supreme Court justices always want to hear generally from the Solicitor General. She needs to file a brief. And a brief, I'm sure, will mimic a lot of what Jack Smith says. But I'm less concerned about amicus briefs, which have an important role. I want to see a Solicitor General brief. And then we'll see the final brief for Donald Trump, which, as you've anticipated, will include things he didn't argue in the first brief and isn't responsive to the arguments raised by Jack Smith in the middle brief, which is exactly what a reply brief is supposed to be. And then we'll see what happens there as you and I wait patiently, along with Karen, for the April 25th, last day, last argument for this term. And we see quickly, because I'll say one thing, I'll turn it back to you, Ben. One thing about this particular lineup of justices. We used to say it's very hard to tell from oral argument in a hot bench how they're going to rule. Forget that. I don't know if it's their attempt to be completely transparent in everything they do now, because we've called them out so many times for being unethical as a Supreme Court. But the one-to-one correlation between what we learn in oral argument and what ends up in the page is mind-boggling to me. I've never seen a stretch of oral argument that so closely mirrors and matches the majority opinion and the concurrence and dissents as we're seeing in this term. So I used to say, well, sometimes it's hard to tell because they'll take a position and it's just a thought experiment. Forget that. We'll know exactly the lineup of votes and who's in the majority and who's on the dissent, just like we did when they ruled for Donald Trump, and even people that we didn't think were going to rule for Donald Trump on the ballot banning issue, 14th Amendment, Section 3. And so that's one thing I wanted to give as sort of a frequent watcher for the last 30 years of United States Supreme Court issues, is how instantaneous the transfer is of things that are discussed out loud by justices during oral argument, and how it ends up almost verbatim in their actual decisions.
We're going to cover all of these oral arguments here on the MeidasTouch network. We're going to have them live on our YouTube channels and across our various platforms. Next week, there's the Mifepriston oral argument before the Supreme Court. We're going to have that here on the MeidasTouch network. That week of April 25th, there's also the argument in Fisher v. United States, or Fisher v. United States, involving the obstruction of official proceeding count in the case against the January 6th insurrectionists. And that's going to be oral argument 2 days before. And then we have on April 25th, this oral argument on the issue of absolute presidential immunity. So a lot happening. We'll stay on top of it every step of the way. And when we give you the analysis, we'll make sure we continue to direct you to the filings, the orders.
Okay, if you like that kind of hard-hitting analysis and debate at the intersection of law, politics, and justice, you've come to the right place. It's the only place, I believe, really, I've looked around on YouTube, that does it the way we do it. It's called Legal AF. It's right here on the Meidas Touch network. Help the Meidas Touch network. It's an independent organization, grassroots. You're building it. Help them get the 3 million free subscribers before before November 5th election. That's the way you can help support us. If you like what we do, where we curate the top 5 developments or so at twice a week at the intersection of law and politics, you've come to the right place. It's called Legal AF, as I just said. So join us on Wednesdays. Join us on Saturdays at 8 p.m. Eastern Time on this YouTube channel. Pick us up on podcast platforms where if you listen to audio versions of podcasts, anywhere that you find them, just plug in. This is me plugging in Legal AF. If you know everything you need to know about Legal AF and you're already part of the audience, thank you. Let me take the opportunity to really thank you for being part of our audience. We just had our 3rd year anniversary or birthday. We started literally with 50 people watching our videos. And now if we don't get over 1 million or so listening and watching one episode of Legal AF, we think we've done something wrong. And that's not because of us. Well, we got the content side, but that's because of you, because you are here with us and we listen to you and we try to improve every day. So take that clip, send it off to friends and family and people in your life and say, hey, just like that. Hey, you like Legal AF? You know that show I love? Take a listen. Maybe you'll join the audience. And if you have no idea what I'm talking about or what I'm rambling on about here in this hot take, I'm Michael Popok. That was Legal AF, and I invite you to join us on Wednesdays and Saturdays at 8 p.m. Eastern Time. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the Meidas Touch newsletter at MeidasTouch.com/newsletter.